Okay, so this is Florida Bar versus Klayman, number 2023-1219.
It is indeed. And if I may quote Justice Curiel to start out from something he said earlier today, due process requires process. And that's the vast majority of what I'm here to argue, is that the manner in which this case has proceeded has denied due process at every turn, starting principally with the District of Columbia, and that this matter should never have been brought. We've also argued that it's time barred. And without getting into the chronology in great detail, which we've set forth in the brief, there is no question about the fact that the actions that are the subject of these complaints that were brought by the District of Columbia involve matters that ranged in time from 2006 to 2010, some 15 years ago. There is also no question about the fact that the 2010 complaint, the Satake complaint, was served in 3 different jurisdictions, including Florida, Pennsylvania, and the District of Columbia. The bar goes into great detail trying to argue that, as the referee noted in his early in the hearing transcript, that we have no conclusive proof that Florida actually received the complaint, but we have in the record a certified Florida bar complaint form that flat out says, in addition to making the complaints for Ms. Satake, I have also filed complaints in Pennsylvania and the District of Columbia.
As an aside, Counselor, can you address the statement on page 72 of your amended initial brief that there is an absence of prior discipline when in fact the referee's report acknowledges that there was in fact a prior public reprimand? Is that an oversight?
Yes, it was. Okay. I learned about the earlier. It was quite a long time ago, quite frankly, and that should have been corrected.
Okay.
And we would have filed an amendment because there was in fact a very minor prior disciplinary matter involving a very limited sum of money, and the court basically accepted that there was nothing significant about it, and there was, I want to say, a public reprimand at that point in time. But yes, there was.
So on the issue of the complaint being sent to Florida, though,
sure.
If we think that the statute of limitations trigger for Florida purposes here, that the relevant date would be when the DC discipline happened, then this proceeding would have been within that. What's the relevance? So, and I know that you contest whether that's the relevant target, but if we think that that's the relevant target, then what other relevance would whether there was a complaint sent to Florida or not, what relevance would that have?
Latches. When you have somebody who's been subject to years of discipline in another jurisdiction, and then Florida's advised about that, the orders that were entered in District of Columbia, and does nothing for 3 years. To me, the idea that you're going to allow time is passing, memories are fading, documents are disappearing. The idea that you can come in and then say, hey, we're going to start investigating, we're going to start prosecuting at this point in time, when you've got a full-blown record laid out for you, suggests to me that latches has got to mean something.
So you would say latches starting from the...
I'm sorry?
You're saying latches as to the 3-year gap?
Yes. Yeah.
Okay.
Because of the time that was involved. Obviously, we've got a 6-year problem if you go back to 2010, and there's no question about a limitations issue. But the idea of latches is that you've got to move expeditiously, and you can't just sit on your rights. And when the clock is ticking, and Florida knows without question that there has been an extraordinary period of time from 2010, when the first Satake complaint was filed, and the other 3 transgressions that were involved in Mr. Klayman's representation adverse to his former employer. one would think that you would want to jump on those actions, because if you look at, as a matter of fact, there was some really interesting language I'd like to quote to the court. I think it was in Randolph, where the court's talking about aspirational goals and how the bar has amended the rules. And what the bar is talking about is prompt prosecution of these bar complaints, because obviously, if a lawyer is doing something that is detrimental to the public at large, he needs to be disciplined. But the flip side of that, as the court notes in Randolph, is that the lawyer is entitled not to have to sit and wait to hear what it is that they're going to do. And what he says was, quoting Burton Young, who was working on the amendments to the bar, accordingly, with the powers of the new disciplinary rule, those who would trespass upon our ethics can expect to be called onto account immediately. There will be no more 2.5-year delays. Final disciplinary action will be complete within approximately 6 months.
Is there a case where we've applied latches as a defense in a disciplinary case? Is there a case where we've applied the doctrine of latches in a disciplinary case?
Not to my knowledge.
So why would we divert from precedent that takes into account the passage of time and mitigation, or in the weight the evidence is assigned, when we have, positive law, essentially a rule establishing a statute of limitations? What would be the justification for this court to set a new course and apply latches? Because
I think the idea of latches is that you can't always pigeonhole something directly into a statute. It's more of an equitable doctrine. It's the idea that something is just, if you look at the entirety of the situation, it's just simply not fair or reasonable. And that's the large part of what's going on here. You have people writing and saying, as a matter of fact, in a couple of the cases we've cited where the courts have thrown out disciplinary action, this court has thrown out disciplinary action for failure to promptly prosecute. In those cases, usually you're talking about matters that are really principally equitable. Was this fair? Was this process fair? In this case, Mr. Klayman was allowed no discovery in the D.C. action. He was not allowed to take any depositions. There's actually testimony in the record from one of the lawyers who was at the proceedings that they were bringing in documents from Ms. Sataki that they'd never seen, because they'd never been allowed to take her deposition, and they'd never been allowed any paper discovery at all. And by the way, that was not a court decision. That was a decision by the D.C. bar not to allow him any opportunity. Now, in what process, on what planet are you required to go in and confront somebody who's accusing you of misconduct and not know what they're going to say and not have the documents that they're going to present for consideration by the panel? And that's what happened here in D.C. And that permeates this entire proceeding. By the way, he was denied the opportunity at every step of those proceedings to take any kind of discovery whatsoever. And,
I'm sorry to interrupt you. Can I give you I just want to give you a chance to address just something that I'm kind of struggling with this case, which is it seems like, there's some attractiveness to the idea that regardless of what happened here, that, it was a long time ago, there was discipline in D.C., adding 2 more years to it might be overkill. On the other hand, seems like there's no acceptance of responsibility, even as to the things that really aren't contested with the conflict of interest stuff. A lot of your arguments here are just trying to relitigate what happened in D.C., which, kind of goes against the idea of just saying, hey, look, be reasonable here. And so it seems like if we were inclined to essentially just treat this more as a matter of quote unquote what's fair, it seems like you're your arguments are kind of cross-cutting, and there's nothing. The more you try to relitigate DC, and the more you kind of don't acknowledge, any kind of wrongdoing or anything, the less attractive your fairness-oriented arguments. And I understand you're in a tough position, but could you just kind of, how should we think about that?
I think that, the quote from this court many years ago, that the process itself can essentially supplant formal discipline. If it takes too long, if too much time is spent on the process itself, and that's part of what we are arguing here. But I think when you don't have a proper record developed, and I think that question really goes to some of the separate claims that Mr. Klayman brought against his former employer. There's just this assumption that there was a conflict, and if you go through each one of the three of those separate events, I don't know that there was a conflict, and you can't tell from this record, because the reality is, representing somebody against a former employer is not a per se conflict, unless you've got some evidence that information that was gained during the course of your employment is somehow being used adverse to the former employer. We've had cruise line cases where the cruise lines went after former in-house counsel who have become plaintiff's counsel, and there's reported decisions saying that's not a conflict unless you're showing that there's information that was gained that's used adverse to the former employer. But that assumption was essentially made in DC, and it's been mimicked ever since. Another involved whether or not the mere fact that a contract had been drafted by Mr. Klayman meant that he couldn't represent someone adverse to Judicial Watch to talk about the fact that they were violating the contract. Those kinds of cases happen in Florida all the time, and lawyers are not necessarily disqualified. If they're going to become witnesses...
You're saying it happens all the time that lawyers draft contracts for one client and then sue the same client over that contract?
I've been representing lawyers for almost 50 years. Lawyers are routinely sued for getting involved in cases where they're adverse to their former employers. Some of them involve internal contracts, some of them involve internal organization. The question really becomes, is there anything that was involved in the prior employment that is necessarily going to be at issue in the new case? If that's the case, the lawyer cannot handle a case. That's a conflict. But there are other cases where a lawyer may be a material witness to the creation of a contract, and the law firm that worked on that with him prosecutes the case, but that lawyer cannot participate at trial because he's a witness at trial. There are cases along those lines all over the state. They happen all the time. The conflict really becomes, are you using information you gained that would not have been public information? Suing somebody for creating a hostile work environment 3 years after you left is not a per se conflict. And there's not a hint in this record of what information would have been used that would have been adverse to Judicial Watch's interests. Nothing. It's just not there. And I can go on because
okay, and you're welcome to keep going, but you're well into your rebuttal.
Oh, well then let me take advantage of rebuttal.
Okay.
May it please the court, Mark Mason and Shanae Hinson on behalf of the Florida Bar.
Can I ask you a question?
Absolutely.
So is a 2-year suspension here necessary to protect the public, or is this more essentially just a punishment?
The 2-year suspension, as opposed to the 18-month, which was the recommendation, was the final finding. 18
months, 2 years, anything. I mean, given the time that's passed, et cetera, that there's already been the discipline in D.C. What's the point of adding on to that?
The referee's holding was that there were substantial aggravating circumstances that led to his decision to increase it to a 2-year suspension. It was already mentioned earlier, the refusal to acknowledge wrongdoing. That was a big one. The pattern of misconduct, we're talking about conflicts of interest that spread over the 3 Judicial Watch cases, and then it also included the the Satake suspension order.
Yeah, but the case for protecting the public from harm seems to me to be substantially weakened by the delay that the bar seems to have taken in this matter. If Mr. Klayman, because of this conduct, was a substantial risk to the public, why did you wait so long to act?
Well, we didn't wait so long to act. What we did was we acted on the Satake suspension order. What he's talking about with the 3-year issue was the Judicial Watch 90-day suspension order. And in that case, it came up during the sanction hearing that there was a question raised about, well, did you notify the Florida bar of this order? And he answered, yes, I did. But I filed a petition for a hearing, and I'd ask that you wait. Didn't follow up with us again. It fell to the wayside, and then when the Satake suspension order comes in, we see, oh, he never let us know about the outcome of that petition for a hearing. It was adverse to him. And so at that point, we moved on both of them together, but we only sought the 18-month suspension when we took the case to the referee, rather than combining the two and stacking them, which was suggested in the initial brief. That didn't happen.
But now, the misconduct here, though, occurred when?
Right, so the Judicial Watch cases spanned from 2006 to 2008, and then the Satake matter was mostly in 2010.
Okay, so now it's 2025, 15 years ago.
Right.
Was he practicing, I know that there was eventually discipline in D.C., but I mean, how many years was he practicing between 2010 and now? And I'm wondering, is there any indication of any wrongdoing in that time?
The 2011 public reprimand happened during that window.
The one here in Florida?
Yes, the one here in Florida that was referenced earlier.
What do we know about that case?
It was a public reprimand having to do with his failure to pay a client a mediated settlement. I believe it was around $5,000 that he said he couldn't afford at the time, so he just didn't pay it. And it took initiation of a bar proceeding before he eventually did pay it. So now what we're here on is substantially worse conduct. And I think that's part and parcel of, when you look at it, a public reprimand.
A mediated settlement over what?
It had to do with his representation of a criminal defendant who was unhappy with his services, and so it was agreed he would reimburse, I believe it was $5,000.
So what do we know, though, about what he's been up to since 2010? So you mentioned the 2011 issue. I'm just trying to get a sense of what because we're talking about, you know, on the one hand, the DC stuff is serious, and just speaking for myself, I'm not really interested in relitigating all that. On the other hand, we are being asked to tack 2 more years onto this to remedy or to address conduct that happened 15 years ago. And I'm just trying to understand, is there anything else? I mean, how long was he, how long for that interim time, I mean, how long was he able still to practice?
Well, he was subject to an interim suspension while the D.C. proceeding was ongoing, and I'm actually not aware of if he got readmitted. He's been suspended in Pennsylvania this whole time, where he was also licensed as well. So I can't really speak to what law he practiced once he was suspended. You know,
when did that start? When did the interim suspension start?
That would have been during the Satake appeal, which would have happened in, I'm not exactly sure the year, to be honest with you. But it happened during the interim of the appeal of the Satake suspension, which led to that, the 2022 order. And so, you know, it went through this very long appeal process, which was part and parcel of the delay, because we were acting on a reciprocal matter. It's not about whether we received something in 2011, which is still just conjecture on his part. It was an unsworn document. It was referenced that, no, it was on a Florida bar complaint form. It wasn't. It was on a Washington, D.C. bar complaint form,
right.
unsworn.
So let's assume that the bar acted within a reasonable amount of time when they brought this. Can you just, what is the point of 2 more years of suspension?
Yeah, the point of 2 more years has to do with the aggravating circumstances that was shown to the referee. I mean, it was the refusal to acknowledge any wrongdoing whatsoever. He's still framing it as though this is a political ideology witch hunt against him. There was the accusations against bar counsel that the referee referenced in the report of referee having to do with bar counsel tipped off witnesses I was trying to subpoena. Absolutely no factual basis to assert that whatsoever, and yet he said it anyway. And it was just that kind of conduct throughout the hearing, and this notion that, I was never entitled to any discovery. He's received hearings and hearings and hearings. The Sataki alone was a 6-day final hearing. And this notion that he wasn't entitled to any discovery, he has to take 2 depositions, and there's a rule in D.C. that said you need to show compelling need to do it. And he simply did not do that. You know, so there's this constant kind of overstatement of no discovery, no due process whatsoever. But it went through a 3-tier review process in Washington, D.C. When it comes to us, we're not looking to relitigate the case, and I'm not going to, bandy about on that point too much longer. We took it and we acted timely, well within, if you say 3-7.16 and the 6-year rule, if that applies at all, it would be triggered when we get notice of those suspension orders. We're well within that 6-year time frame. So what he's talking about is D.C. took too long. And their orders said the delay was unfortunate. There's not really an excuse for it. But we have in our standards unreasonable delay. It's a mitigating factor at best. I'm not saying it doesn't apply, but it was not argued in the initial brief. It wasn't found in the report or referee. It can apply. But ultimately, when you look at all these aggravating factors, the selfish motive that he had with pursuing these complaints in D.C. and drawing up all this media attention and all that, and you combine it with this multiple offenses in this pattern, that's what the referee was looking at to say, this is worthy of rehabilitative suspension, and in this case, a 2-year suspension based upon the 18-month suspension order, his conduct during the proceeding, and his priors. They did a 90-day suspension and the public reprimand.
Could I ask a question? And I'm sorry if you've already said this, but I want to clarify. What is Mr. Klayman's current status with the Florida Bar?
His current status is he's licensed.
Okay.
Yeah.
But he's not, there's no suspension?
No, there's never been any action on his license by the Florida, other than the public reprimand in 2011. But yeah, no current action on his license. He hasn't received any penalty for it at this time. So, at this point, this is what the purpose of a reciprocal discipline is for. We don't relitigate. We accept the findings of guilt unless he can establish his burden. And his burden is grave injustice, a paucity of proof, a complete want of due process. That's what the case law says. He hasn't established that. What he's established is that he raised due process arguments in D.C., and they failed. It went through a 183-page order in first review, and then another order saying that order went recommending a 33-month suspension was too much. We're going to drop it to 18.
I'm sorry to interrupt you,
yeah.
But the logic, it seems like sort of the logic of the reciprocal discipline and the reason why we don't relitigate and all that is just the idea that, you have a problem in another state, you go through the process, it results in some kind of discipline. In a perfect world, if someone else with due process has already decided this person shouldn't be practicing and offering their services to the public for 2 years, you would want to protect people in Florida for the same 2 years. I think the problem here is the stacking of the time, especially in a context where the wrongdoing is from 15 years ago, basically. So can you address that?
Yeah, I think a lot of that has to do with the way these cases get litigated and dragged out for so long, very frankly. A reciprocal discipline should have been a very quick matter in which there would have been overlap.
Do you agree that in theory that if you're just looking at it from a common sense perspective, that, if DC thought that, the public needed to be protected from this person for a couple of years, that you would give Floridians the same protection, and then everybody moves on, and hopefully the person acts the way they should going forward? Isn't that the way ideally it should work?
Correct. In D.C., what they said in the suspension order, the Sataki suspension order, was that he needed to demonstrate his fitness before being reinstated to the practice of law. I think that's very fair to ask for in this case. The referee thought it warranted a 2-year. The bar requested 18 months, same as a suspension order, and I think that was fair based upon the pattern of misconduct that he's done here. We didn't add on the extra 90 days from the judicial watch suspension order he found. We recognize that one is a bit older, so we weren't going to push on that. But when he acted as he did in the proceeding, and it resulted in a very delayed proceeding, you know, it resulted in a lot of accusations thrown out about what bar counsel did with tipping off witnesses, the case is going to take longer. And so to complain that, well, now it's 2025, well, it's 2025 because he took 7 years to appeal just that judicial watch suspension order. There's specification to charges in 2013 on that one. And that's how long it took before a 2020 suspension order came out. He did a 3-tier review process every single time where it got written opinions all the way up to the District of Columbia Court of Appeals, and they ultimately concluded that was always going to take a substantial amount of time. He's not attributable to all the delay. I'm not saying that. I understand D.C. took a while to bring the case, longer than they should have, but he wasn't prejudiced by it. He's talking about lost documents, memories faded. They rejected those arguments. His recollection was fine. Ms. Sataki's recollection was fine. That was the finding. He didn't identify a single document he needed or that he lost. Why would he get rid of them? She made the complaint in 2010 and a supplemental in 2011. He was on notice of those complaints. Why did he delete records that he's saying he deleted? It doesn't make sense that he would do that because he was never told the case was closed out. So all these notions that these due process arguments resulted in a paucity of proof or a want of due process or grave injustice, these are just typical arguments that were brought and failed.
Go ahead.
I'm sorry. So what do you say in response to the counsel's argument that he was denied discovery? Would you specifically address that?
Yeah, and I'd like to be specific about it because the discovery he requested was to depose 2 witnesses. One was Ms. Sataki, and one was her psychiatrist, a Dr. Aviera. With Ms. Sataki, with the rule being in Columbia, you need to demonstrate a compelling need. She was coming from California to D.C., and so the way they do it in D.C. is at the ad hoc committee, they put her on, they did her testimony, and then he did substantial cross-examination. And what I mean by substantial is she testified for 3 of the 6 days of that final hearing. He was not limited by what she said in cross-examination. He's exploring other avenues throughout that entire proceeding. Now, is that...
You're saying he basically got the discovery in the proceeding?
Yeah, he got the discovery in the proceeding. He was allowed to explore, and there was a break before they continued on with other witnesses so he could prepare his case in chief as well. With regard to the psychiatrist he wasn't allowed to depose, that was addressed in the suspension order. The testimony she would have offered was insubstantial. Most of it would have been privileged anyway, although he falsely claimed that there was no doctor-patient privilege regarding that doctor. But on top of that, he just wanted to explain that any emotional issues with Ms. Sataki, alleged emotional issues, were not his fault. It was completely irrelevant to what the rule violations were, which was a conflict of interest, which was frankly established just by his emails that he sent to her alone and nothing else. So there wasn't just no due process. He wasn't allowed to take 2 depositions. That was it.
So in the unusual situation here, though, I mean, if he got a 91-day suspension, he would have to show, if he wanted to be reinstated in Florida, he would have to show essentially that that the problems have been addressed. The bar would have a chance to look and see what he's been up to since 2010. They'd be able to see what the status of what's going on in D.C. and Pennsylvania is. I mean, why isn't that enough to protect the public?
I think it's not enough to protect the public just based upon what the referee found in terms of the aggravating circumstances. Mainly his refusal, but also the pattern. And just, this is someone who has had a lot of time to reflect on conduct that happened as early as 2006 through 2010, and he still has not acknowledged a single bit of wrongdoing.
It really sounds to me like it's almost more punitive, and partly just based on the behavior in this proceeding itself.
I think that the referee had a unique vantage point to gauge whether this is someone who should be given the shortest amount of time before petitioning for reinstatement or a substantial amount of years. And I think that the referee's report justified why he didn't just accept the 18-month suspension and decided to increase it to a tier 2-year recommendation. With that, I see I'm over my time.
I think I interrupted someone.
Okay.
Oh,
can I go?
I'm sorry.
Do you know when the bar got notice of the 2022 order?
Yes, actually. It was in October of 2022. It was one of his exhibits, if I can find it here.
Okay, so it was October of 2022 when you were aware of the DC discipline.
Correct. And in that letter in which he notified us, he also asked us to stay the proceedings while he did collateral attacks of it. So I just kind of wanted to add that in to explain.
So
a lot of the delay is not.
When did the bar get notice that it was done?
The October 2022 is when he notified us. That's when DC had concluded the Sataki matters, yes. But he was still planning on suing in other avenues to attack the judgment, and he asked us to stay.
So it was
at that
about
point.
a year, almost a year after that you filed the petition for reciprocal discipline.
Our complaint for reciprocal was in August of 2023, so yeah, a little less than a year, yes.
You can have 30 seconds to finish up if you want.
All right. I would just like to say in closing that I believe that the referee justified it with the case law, particularly the Rush case, where you're prioritizing a client's interests, or excuse me, prioritizing your interests over the client's to the detriment of the client. That was a 3-year suspension. I'm not suggesting he needs that much, but there is case law that the referee addressed supporting that, and for that reason, I'd ask that you accept the 2-year suspension. Thank you.
Thank you very much. Has your client been reinstated anywhere? And I apologize that I don't know this. Has he been reinstated in D.C. or Pennsylvania?
Yeah, Pennsylvania had a CLE requirement. That was all. There was no, I don't believe there was any suspension of the matter. I'm sorry? During the pendency of the appeal.
What about D.C.?
As far as I know, D.C. itself actually gave notice to both Florida and to Pennsylvania about the results. So it's not just a matter of...
No, but is he still suspended in D.C.? Has he been readmitted in D.C.?
As far as I know, he's not applied for reinstatement.
He hasn't applied?
I did apply.
You did reapply? Okay. The problem I'm hearing with this is that if you don't get discovery in the first place and you're not allowed to take depositions, the idea that he may have been able to cross-examine this witness cold, Ms. Sataki in particular, really does very little in terms of due process. Because the reality is you don't have an opportunity to look at the documents. You don't have an opportunity to find out if she's got other documents. Even from the documents that are submitted by Ms. Sataki in this case, they are back and forth for a better part of 8 months throughout 2010 as to what's going to happen, whether or not it's going to happen, how it's going to happen. No lawyer in Florida is obligated to get a client's authority to do anything other than the ultimate goal that is the client's aspiration. You don't talk to the client about how you're going to prosecute every case that you're going to take on. But at the same time, you can't cross-examine anyone about what they believe their opinions were or what they were telling you to do when you don't have access to communications that were being had. For example, with her union rep, who testified under oath in this case, along with the young lawyer who went to the hearing about the hostility that was directed toward her and to him at one point or another by Judicial Watch. In fact, the lawyer who testified in this case testified under oath about the manner in which Mr. Klayman was treated by the D.C. bar during those hearings. And I would ask the court to take a close look at that testimony because it's very clear that things were, in this day and age when everybody talks about weaponization, it's the first time I've ever used that word in my life. If you look at the way this prosecution went down by the D.C. bar, there was nothing about it that was really afforded any manner of due process. And that resonates throughout this entire case. the concept of conflicts morphed and has morphed in this case. First, it was he was doing this for his own personal good or to advance his own reputation. Then it was because he had a romantic interest in Ms. Sataki. Judge Lamberth himself, who denied the motion on the conflict issues and denied the opportunity to take depositions, said that it was a close call. He has referred lawyers on multiple occasions to the bar.
Sir, I'm sorry to interrupt you. You can have 1 minute to finish up.
He felt that in this case, there was absolutely no reason to believe that, as the 11th Circuit, the D.C. Circuit noted in its opinion, any reason to believe that Mr. Klayman couldn't and wouldn't practice ethically and competently, and in fact commended the manner in which all these cases had been handled. So, you look at all of these people who testified in this case. The only one who testified adverse to Mr. Klayman was Ms. Sataki, and she was impeached regularly, as was noted by the Court of Appeal on multiple issues when confronted. Well, that's the whole point, is confrontation. To be able to confront someone, you're entitled to rudimentary discovery and at a minimum a deposition, and not have to do it cold.
Okay, thank you very much. We'll be in recess for 10 minutes.
Thank you.
All right.